Hello and welcome to the interview. I'm speaking with Rohan Edrisinha, who teaches constitutional law at the University of Colombo, the Faculty of Law. Rohan, warm welcome to the program. We're just after a presidential election, and I know that leading up to it and on the day of the presidential elections and just after it, you were a frequent voice alerting the public and the voters on the constitutional nature, the importance of the elections, and also thereafter this whole issue about when the president actually begins his second term. It's gone before the Supreme Court. If you begin with that issue, the Supreme Court has issued a judgment in that regard. I know that you had an intervention that went up on video. What do you make of the judgment? I mean, one of the responses I get, for example, Rohan, is that it defies, in a sense, common sense to have a president start so long after he or she was elected into office. But this is, I guess, we're all hostage to a bad constitution, is it?
Exactly. Yeah. I mean, the Third Amendment to the Constitution that was introduced by J.R. Jayawardena, which was, in a sense, an act of constitutional manipulation, does provide that a president who is elected to his second term, if he has opted for an early election, that his second term begins on the date that corresponds to the date of his first election. Illogical, it doesn't make sense at all, but that's what the text says. Now, when there was a controversy about Chandrika Kumaratunga's term, there was a case that went before the Supreme Court of Sri Lanka, Reverend Omalpe Sobita versus Dayananda Dissanayake, and in that case, the then Chief Justice Sarath Silva sort of basically took the argument that you put forward, that it went against common sense, it was sort of unfair, and he held that the date of commencement of the second term should be the date on which the results were announced.
Right.
But what happened this time was the Supreme Court, 7 judges sat, there was a very short hearing, and the Supreme Court apparently has held that the president's second term begins in November 2010. So they have stuck to the text of the Constitution, and indeed in the hearing, the Attorney General urged the Supreme Court to stick to the text of the hearing. Now, I'd just like to make one point. I also intervened in the case and made submissions, and I made a plea that the determination be made public. But to date, it has not been made public. So you and I cannot even see the determination, see why and how the Supreme Court has reached its particular conclusion. And I really think that this is very unsatisfactory. The President under our Constitution can refer a matter to the Supreme Court for an advisory opinion. This is what the President did. The Constitution says that the Supreme Court has to give its determination to the President. It doesn't prohibit the determination from being made public. And that's the point I made. Because as you know, Sanjana, this is a matter that affects all of us. It affects all the citizens. Everyone is talking about it. But to date, not one of us has seen a copy of the determination, not even some of us who intervened in the hearing.
But why not? I mean, why is this?
Well, the Supreme Court has taken the view in the past that when it gives an opinion on a matter like this, referred to it by the President, that it has a duty to communicate the opinion to the President and no one else. And I really think that the Supreme Court should take the view that while it might give the President the opinion first, thereafter, the opinion should be made public, should be on the Supreme Court website if it has a website, or should at least be distributed to the media.
Now, in the past, with the former Chief Justice, were those determinations made public, either subsequently, maybe not immediately, but later on?
Well, as far as I know, not by the Supreme Court.
Right.
What happened was the determination, the Presidential Secretariat took a decision to make it public, or it was leaked, or it was in the interest of the government to make the opinion public. I mean, the ICCPR bill advisory opinion is a case in point. But so far, this particular determination has not been made public, and I think that's very regrettable.
I mean, in terms of the problems of the Constitution, we have seen, for example, in his first term, the President beginning this process of all-party representatives movement, a body to grapple with this task. It went nowhere. It disappeared off the radar during certainly the campaign time. Its leader, Professor Tissavitharana, has said that it will be reanimated now. what are your hopes? Where is it now, Rohan, and what are your hopes of it coming out with something substantial?
Well, I'm not very hopeful at all because, as you said, it didn't figure in the election campaign. President Rajapaksa is supposed to have said before the campaign started that he will sort of focus on it again after the election. That was after the presidential election. I can almost imagine now the argument being put forward where we'll focus on it after the parliamentary election. And if you look at the some of the recent statements, the Independence Day statement, for example, made by the president, there doesn't seem to be any emphasis on the question of constitutional reform. And I think that's very disappointing. But might I just say this, that the APRC started off with the appointment of these two expert committees. Well, it was actually one experts committee, but then they divided up into two groups. And I do think that both the majority report and the minority report are worth reading. The majority report, of course, is something that I could identify with. It basically argues for a 13th Amendment plus type solution. But the minority report, which was authored by people who have great misgivings about federalism and devolution of power, was extremely well written. And I do think that anyone who is serious or interested in looking at constitutional reform from the point of view of conflict resolution should read the minority report, because I thought it was the best possible case that could be made against devolution based on regions or provinces.
Right, now I'll come back to that, but I mean, I'm paraphrasing here, but I did read recently on the BBC website that the president had made reference to a people-centric devolution in his Independence Day message. I don't know what the exact words were, but there was certainly a reference to devolution being anchored to the peoples. How do you interpret that?
Well, I'm a little concerned about that because I think there was also a reference to villages and districts. And while I have no problem with the idea of strengthening local government and strengthening what I would call the third tier of government, if we are looking for a solution to Sri Lanka's ethnic conflict, and if we understand the history of that conflict and what people like Gigi Ponnambalam and S.J.V. Chelvanayagam were campaigning for in the 50s and the 60s, then I think it is very important that in addition to a strong third tier, we also have devolution to the provinces or to the regions. And I am very concerned that some of the people who advocate this sort of district-based or village-based devolution talk of that as an alternative to devolution to the provinces. And I think that if that is done, that would be an extremely dangerous message to send to the Tamil community, and the Tamil community would feel that the government and the people who advocate that just have no understanding of the history of the ethnic conflict and what their aspirations are.
Are we going around in circles, concentric circles in a sense, reductionist circles? Because this entire debate about constitutional reform, irrespective of how you come into it, pro-anti-federal, pro-devolution, anti-devolution, seems to be going around and around ad nauseum, ad infinitum. Where do you see progress in this, the second term of the president? Or let me put it another way, what can he do, if he so chooses to do so, to kickstart this process, or to give it more meaningful impetus, direction,
well, I think the first
energy,
thing,
whatever, I mean, you know.
Yes, I think the first thing is to understand the conflict and understand the evolution of the conflict. I think that if someone thinks that devolution of power or decentralization based on districts can solve the problem, that person is obviously totally unaware of things like the Bandaranaike-Chelvanayagam Pact, the Dadisen-Naika-Chelvanayagam Pact, the Mangala Munasinghe Parliamentary Select Committee. The conflict has evolved, and if you're thinking about a reasonable solution, it surely must take the history and the evolution of the conflict into account. And this is where I feel that the people in the present cabinet who are aware of this, people like Tisavitarna, Sara Tamanugama, G.L. Piris, these people have got to assert themselves, and they've got to ensure that there is an intelligent kind of debate within the cabinet, within the government, so that the proposals, if and when they do emerge, are reasonable and take history and the evolution of the conflict into account. I'm almost frustrated that the government's statements and what they're proposing does not seem to take this history and this context into account at all.